I just want to thank you, you and your fellow colleagues, lawyers who go in Rwanda into the ICTR to continue your fight for justice amidst such an unfriendly environment. That's it.
Thank you. That's very kind.
Other than Uwakindi, have there been other cases referred back to Rwanda, both at the ICTR and from other countries?
Yeah, there have. Uwakindi was a real opening of floodgates case. There has been one other case of, as it were, a person in Arusha who had been arrested, who has since been returned. A number of other, in fact, the majority of other Rwandan indictees at the ICTR have had their cases returned or transferred to Rwanda on the back of Uwakindi. Uwakindi was a very dangerous precedent, and as sure as night follows day, it's going to be relied upon by national courts around the world, asked to deal with extradition requests from Rwanda, and until one brave court in a third country looks at the material afresh without simply blindly following what the referral chambers' conclusions are, things look pretty bleak for Rwandans in the diaspora who, for whatever reason, are being sought by the regime in Kigali.
My question is in terms of...
Could you identify yourself?
It's Nell Stanfield, criminal lawyer.
Hi.
In terms of politics of the situation, do you hear or do you know or can you speak of whether the UN has applied any pressure to transfer these cases to wrap up the ICTR more quickly?
One always has one's suspicions. I think before the Security Council, the continued existence and the continued expense of the ICTR was becoming an increasingly difficult issue. And whilst I would never suggest that the judges of the ICTR were succumbing to any political pressure from one direction or another, some people may think so. I couldn't possibly comment.
David?
Still on. I think I was the first person to do it and not have to press a button.
Well done.
David Jacobs. I actually had the pleasure of working with Iain on the Kenya Kiga case, which actually is one of the cases where some years ago a referral to Rwanda was refused by the court.
Yeah.
And there was an attempt to appeal that, and the appeals chamber also refused it. Just on reflection, when I was listening to it, doesn't it seem, at least it seems to me, that the whole legal raison d'etre underpinning the ICTR is fatally undermined by the referral of cases to Rwanda. The ICTR was set up by the UN as an ad hoc tribunal, not a Rwandan government tribunal, and it didn't rely on the Rwandan government to do these things. It wasn't even set up in Rwanda. It was set up deliberately in Tanzania. Of course, the original thesis was that they were going to be prosecuting both sides, and there must have been a host of rationales for setting it up outside Rwanda. But the whole idea of complementarity and so on seems to be undermined, is undermined, by the idea that the ICTR, well, we've burbled along now for a decade or so, a little more, and now we're just going to toss everything back to Rwanda. Which leads to the question is, why do you exist in the first place? Why do you continue to exist? And the suspicion one had at the beginning was that at the infancy of the Kagame regime, Kagame's prosecutors couldn't travel around the world to Belgium, to France, to this place, to that place, and say, well, we really want to get that person. We really want to get that person, extradite them to Rwanda, because the impulse of most nations, well, we're not going to do that. On the other hand, if, as may have happened, the government of Rwanda is able to say to the prosecution at the ICTR, we want these people, it's much more legitimate in the eyes of the world for the United Nations International Criminal Tribunal for Rwanda to go to the Belgian government or the Canadian government or the so on, say, extradite people not to Rwanda, to us. In a few years' time, we'll funnel them back to Rwanda. But right now, it's just us. It seems to me to undermine all of the stated principles on which an independent international criminal justice system is supposed to be based.
Yeah. Well, I mean, we should remember that the ICTR, the setting up of the ICTR, was very much opposed by Rwanda in the first place. Largely, I believe, I may be wrong about this, but largely I believe because Rwanda wasn't happy that any UN tribunal wouldn't be able to impose the death penalty. 11 bis doesn't just talk about referrals of ICTR cases back to Rwanda. It doesn't specify Rwanda at all. It says that referral can take place to any country where the fair trial rights of an accused person can be properly guaranteed. And in fact, in the history of the ICTR, there have been 11 bis transfers back to one or two European countries. I personally don't have any great philosophical difficulties with it, because if there is another country that is willing and able to fairly try under the principles of universal jurisdiction somebody charged with genocide or what have you, then fine, let them. But my concern is when a country is requesting referral back to their, back to the jurisdiction of that country, where fair trial rights cannot be guaranteed. I have no difficulty philosophically with people being charged with the sort of crimes that they're charged with, of being put on trial. I think it's important, as long as the trial is fair, and that really is the key. That's the key criterion.